Hello, good afternoon. It is 1 o'clock Central, so we're going to go ahead and get started. My name is Jordan Walker. I'm an attorney with Seaver Walker Paget Law Firm. I'm here to talk to you about eminent domain in the state of Texas, what to do when the DOT wants your land for a road project. With that being said, we'll go ahead and get started. Again, I am Jordan Walker with the law firm Seaver Walker Paget. And today we're going to be talking about eminent domain. We're going to talk about what to do when the state needs your land. We're going to talk a little bit about this road project, the FM 2493 project, and then we'll get into the eminent domain. So yeah, the FM 2493 project is a plan to widen the FM 2493, commonly known as the Old Jacksonville Highway, basically from south of Tyler down even further south of town. It's going to widen most of the road from 4 to 6 lanes, add medians, and it is pretty much your standard road widening project. And that right there explains exactly what's happening, although a lot of landowners already know more about the project than we do oftentimes. But nonetheless, that's some baseline information about what's going on with this project. Our understanding is they are acquiring land as we speak. This is recording on October 31st, 2024. So they already are acquiring some land on this project. I don't believe they've acquired all of it. So we are having this webinar to try to talk to landowners for those that have not settled with the DOT yet, have not resolved their matter yet with the DOT, to kind of explain what's going to happen here in the near future. Before we get into that, I want to talk briefly about what eminent domain is. Eminent domain is the forced acquisition of private land for public use by a entity with eminent domain authority. Eminent domain authority is usually, or most traditionally, exercised by the DOT, cities, counties, municipalities, government entities, although other entities, well, private entities such as pipelines, power lines, they also have eminent domain authority. In Texas, TxDOT and the cities have presumed inherent eminent domain authority, meaning they can take if they would like, or they have the inherent ability to file the lawsuit at least. Stopping these types of takings, which is a common question we get, can you stop the project? Can you change the project? Can you maybe move it somewhere else? I will say it's very difficult to stop takings anywhere. That's not limited to the state of Texas, especially when the takings are done for road projects. Road projects are de facto public uses. So it's very difficult to challenge an acquisition on those grounds. It is possible to challenge acquisitions on the grounds that the DOT did not follow proper pre-suit negotiation procedure, which we'll get into here in a bit. But even then, stopping takings on any grounds, very difficult, but it is not impossible. We've done it before. It's a very fact-intensive analysis that needs to be done to see if a taking can be challenged and see if you can be effective. We're not going to talk a ton about stopping the taking, changing the project. We're mostly going to be focused on eminent domain and maximizing your compensation for the acquisition of your property. Because ultimately that's where your fairest fight is going to be, and not necessarily stopping the taking, but making sure that you get paid what's referred to as just compensation for your land. Just compensation is money, of course, but it has to be just. It has to be representative, encompassing of everything you're entitled to for your acquisition. Oftentimes in these scenarios, the DOT will come in and they will make offers that are not representative of just compensation. A lot of times they come in and lowball landowners, necessitating the landowner to fight for more. Now, luckily, unlike stopping the taking, getting more money or getting the right amount of money is a much fairer fight. You are entitled to a jury trial over compensation in eminent domain. So ultimately, it's not up to you, or it's not up to the Texas Department of Transportation or the city or the county what you get. It could be up to a jury if you take it all the way to the trial. And so, in other words, you have the right to a jury. You have the right to present your evidence on compensation for the taking of your property. But let's talk about procedure, because I think that's the The most important part of this process right now for landowners is, how does this process work? What happens when they need your land? Um, and as it turns out, in the state of Texas, much like many other states, there are pre-condemnation requirements, meaning whether it's a DOT, a pipeline, power line, city, county, you name it, whoever's taking the land, prior to initiating an eminent domain lawsuit to take your property, they must meet certain pre-condemnation requirements. These are statutory, these are required, these are a matter of law. And they have to be done in consideration of a certain schedule, meaning they have to give you a certain amount of time before they go on to the next step. Now, as you'll notice probably on this slide right now, there's various days identified. This is I've put together a schedule on the quickest possible statutorily permissible schedule, meaning if for whatever reason the Texas DOT wanted to just go as quickly as possible through this process with you personally to get your land as quick as possible, this would be the quickest, the quickest schedule by which they could get it as allowed by statute. This is not a hard and fast schedule. These acquisitions are not traditionally undertaken with this amount of expediency, but they theoretically could. And because they could, we are going to discuss it as if they are going to be, again, as quick as possible with the acquisition of your property. I think it's fair to assume that they won't move that quickly, but we just want you to be prepared and know that it could, because it's a better start from what could happen as opposed to what you think will happen. So the first day, let's say today, you receive an offer from the DOT, and we'll just keep it simple. We'll say that offer was $50,000. This offer can be written, it can be verbal, but ultimately it needs to be issued, and it very likely will be issued in writing. Most of these communications with DOT will be done in writing, even though they don't necessarily need to be. So the first day you've received an offer, and you are allowed to negotiate. However, we generally don't advise negotiating without at least talking to an attorney first. But regardless, you've received your offer, and then let's say you didn't do anything with it. You got it, and you put it in a stack of papers, and you forgot about it. Well, assuming the DOT really wants your land, a little 23 days later, or over 3 weeks later, this would be the soonest possible time they could issue this. The DOT can issue what's referred to as an LBOR. The LBOR stands for the Landowner Bill of Rights. Landowner Bill of Rights, as you might imagine, a list of rights, landowner protections codified in Texas law. These are protections for landowners faced with eminent domain. These protect landowners and impose requirements on condemners to meet in their exercise of eminent domain authority. So they will provide a copy of this to you, and they must provide a copy of this to you at least 7 days prior to the final offer being issued. And we'll talk about what that is here in a bit. There's a decent chance that they issue this with the initial offer or prior or around that time. So I think it's fair to assume they will issue, but at the latest they can issue it is 7 days prior to, at least, I should say, the latest they can issue is 7 days prior to what's referred to as the written final offer. The written final offer can only be issued 30 days, at least 30 days after the initial offer. So they can't issue a written offer before 30 days has lapsed since the initial offer was issued. And so at day 31, again, assuming they're on an expedient timeline, they will issue a final written offer. Again, as you might imagine, it needs to be in writing. And part of that, they also need to provide an appraisal report, which the offer must be equal or greater to than that report. So on using the same $50,000 offer example, assuming they issue the same $50,000 written final offer, that $50,000 must be either what the appraisal says or above what the appraisal says. So if the appraisal says you're entitled to 70, the written final offer cannot be 50, must be at least 70. So they need to provide the appraisal report. They need to provide a copy of the conveyance document. What are you selling to them? What are you relinquishing? Usually in the form of a deed or an easement. They need to supply a plat map that depicts the acquisition on your parcel. And obviously it must be written. It must be in writing. So, and just as a point right here, our firm, our involvement gets involved as soon as the offer is issued. And sometimes in select instances, we will begin representation before the offer is issued. But as soon as the initial offer is issued, we are able to do our job. We know what the acquisition is. We know what's being offered, and we can evaluate that offer to give you our thoughts on how good or bad that offer is. Okay, so we got past the final written offer. What happens next? Well, it's day 31. At that point, they can't just, they issue that final written offer to you, you say, no, we're not even close. What happens then? Well, the DOT has to wait 15 days, at least 15 days after the final offer. But on that 15th day, they can they can file that lawsuit against you. So they file a condemnation petition. At this point, once you've been suit's been filed against you, you are in eminent domain, so to speak. It is an eminent domain lawsuit. The lawsuit's purpose is twofold. The first purpose it serves is it needs to get your land for the project. So the eminent domain lawsuit, the first purpose is for the DOT needs to get your land. It serves that role. The second purpose that the condemnation lawsuit serves is determining how much money you're entitled to for that acquisition. So the petition serves the function of the DOT because they need the land. It also serves the function for you of allowing you the opportunity to get just compensation before a jury trial if it gets that far and if you choose to let it get that far. So the lawsuit's been filed. The lawsuit is filed in the county where the property is located by the DOT. And as soon as the petition is filed, you will be served a copy of that petition. A service process agent will serve you the paperwork. And as soon as that petition is filed, or around the same time the petition is filed, the court, the judge of the court, will appoint a board of commissioners. And the board of commissioners, the main requirement of them is that they simply live in the county where the property is located. And the board of commissioners' purpose, and remember that I said there was the condemnation petition serves two purposes. The board of commissioners serves the purpose. The board of commissioners' purpose is getting DOT the land. So what happens is once the petition has been filed, the board of commissioners have been appointed by the judge. Again, probably between at least 20 days after their appointment, plus another 10 days to allow the parties to strike any of the board of commissioners for cause, at least 20 days. But you're looking at, at least 30 days rather. You're probably looking 30 to 60 days from the point of the lawsuit being filed to actually having the board of commissioners hearing. The purpose of the board of commissioners hearing is to determine preliminary compensation. And so they'll have a hearing. You can participate. The DOT can participate, and both parties will present evidence if they so choose. Ultimately, the board of commissioners will have that hearing. They will render effectively a verdict of preliminary compensation that they feel you are entitled to for this acquisition. The DOT then has the option, which they will exercise, to deposit that compensation with the court. This determination, this preliminary compensation, is exactly what it sounds like. It's preliminary. Ultimately, the purpose of that preliminary compensation is to determine some amount of money that they feel is appropriate that the DOT can then deposit, and then in exchange for that deposit, the DOT gets access to your land to begin work on the project. And so they will get access to your land before your case is even over. Ultimately, though, you do have the option, if you choose to elect to take this case all the way to a jury trial again to determine final compensation. But in order to get to that step, going back to the board of commissioners determination of compensation, let's say, going back to the $50,000 example, let's say the board of commissioners, so the DOT has offered you 50, you say you feel you're entitled to 150, and they have this hearing. You present evidence, they present evidence, and the Board of Commissioners says, okay, we think you're entitled to $100,000. They deposit the 100, they get access to the land. But let's say that you disagree with 100, you think that's still too low. You can then file an objection to that report. And if you timely file it, which you need to timely file it in order for the case to continue, you can then basically appeal that decision to a jury trial to determine final compensation. The DOT also has the option to do that. So in the same situation, let's say they offered 50, the Board of Commissioners says you're entitled to 200, and you're fine with that, but the DOT is not. DOT has the same option you do. They can disagree with that amount of money, object to it timely, and then again, the case proceeds to potentially a jury trial over final compensation. If neither party objects to that amount timely, the case is over. The DOT gets the land, and that amount of money becomes final compensation. There is no jury trial. So you need to file objections if you want a jury trial, if you disagree with the Board of Commissioners amount. This is a relatively compressed and aggressive condemnation schedule. It is also, again, this is an even more aggressive schedule because we are assuming that the DOT is filing everything as quickly as possible, which I don't think is a fair expectation of what will happen. These things generally don't move at this speed, even though they theoretically could. I want you to be prepared for that possibility just because it's better to be prepared for that than not. But relatively speaking, condemnation in Texas is an aggressive schedule, more so than other states that we work in. So that's all to say that you need to be on your toes, so to speak, in these scenarios to make sure that you are responding timely to overtures, postures, or any litigation filed by the DOT. Because if you don't respond at certain points, you could lose your right to getting more money. So it's important that you stay on top of it, or enlist an attorney that is aware of these deadlines, the schedule, so that they and allow them to do their job. So that's the beginning to the end. I do want to also note that we talk about eminent domain, but from a practice note, few of our cases actually reach jury trials. I would say less than 10% of our cases will actually reach a jury trial. Most of our cases are resolved either pre-suit or during the eminent domain litigation at some point before a jury trial. Of course, some of our cases do go to trial, but most of ours do not. And what I tell people is that the bigger the difference in opinion between you and the DOT, the longer a procedure and a proceeding you're looking at. Because generally speaking, the higher the numbers, the more it takes people to come to terms with what the risk is associated with these, what the real risk associated with settlement at certain points. So even though we're talking about the full process, roughly, again, not a lot of our cases reach that, and a lot of times we're able to reach a resolution without getting all the way to the end. Though, of course, we are qualified and ready to go the distance as necessary and as our clients prefer. So I talked a little bit about pre-condemnation. I want to go back to that a little bit, and I want to talk about what to do when you receive an offer. And this is all, of course, pre-condemnation, pre-eminent domain, when they make that verbal or the initial offer and then the final written offer. So when you receive that initial offer, or you're about to receive that initial offer, this is what I tell folks to do. First of all, I tell all my potential clients, existing clients, insist that the right-of-way agent communicates with you via email only, or just in writing. I generally don't advise meeting in person. I don't advise having phone calls. I tell folks it's better to have a record than to not have a record about what the promises are that right-of-way agents are making, what they say they will do, what they say they won't do. Because if you have that on the record, it's a lot easier to go back to it in the future and say, listen, you already promised that you would do this, so we would still like that. So that getting everything on the record as much as possible can't be stressed enough. What I tell people, what I tell potential clients to do when they're waiting for an offer, or when they're about to get an offer, or when they do get an offer, that once they get it, just send a right-of-way agent back. An email's fine. Just say, thank you. I will review this and get back to you in a week. The reason why I say this is that this it accomplishes a couple things. One, it gives you time, but not too much time, but it gives you time to get the offer, get a second opinion, get some get some advice, and consult with an expert or somebody who knows what they're doing, so that you can make a coherent and cogent response if you choose to and if you want to. A week gives you enough time to do that, but at the same time, it also demonstrates to the DOT that you're not blowing them off, and you're not, this isn't something that you're just gonna, oh, thanks, and you never talk to them again. You don't want them to rush into something that maybe you don't want them to do. In a week, they're not going to do anything, and they'll allow you that, and that'll give you enough time to respond. And that way, you're not immediately responding. You're doing it with some level of knowledge about the situation, and you're not hurting yourself at all. So I think that's a fair response. In the interim, once you get that offer, you can contact an attorney and see if they can help you out with this case. As an example, if you get an offer and you send it via email, another benefit to this is that you'll have it handy and that you can then forward it on to your attorney or whoever you want to review it, as opposed to getting it in person, then having to scan it or take photos of it. If you have them just email it to you, then you can forward it to whoever you'd like. So in the interim, contact an attorney. If you contact us, I'm happy to review your offer for free, give you my thoughts, and you can decide what you want to do. And then finally, I would avoid in-person discussions and negotiations. Again, for the reasons stated, you want to get everything on the record. And if they're saying anything that they're willing to do for you, you want to make sure you have that via email or something that you can point to later. What not to do when you get an offer. So these are things, obviously, when you get it, there's an impulse to jump into negotiations and start doing what you think is correct. And a lot of times these impulses are not smart or not advantageous for you. What I tell people is I generally recommend not to engage in negotiations, talk about the property, talk about value, talk about anything really with right-of-way agents without first contacting an attorney. Ultimately, you're not an appraiser. A lot of people might have an understanding for property values in the area, but ultimately you might not even know what you're entitled to. So when you start talking value, but you don't actually know what you're entitled to, you're speaking from a place of ignorance. You might say something that might end up hurting you down the road. An example would be back to the offer. Let's say they offer you $50,000 and you say, well, I want 100. And, you might even accept that, but then you get second thoughts and then you contact me and you say, well, I accepted this offer. I want to get your thoughts on it. Should I have done that? And this has happened before, and I'll look at the offer and I'll say, okay, you might have doubled that terrible offer from 50 to 100, but you might have left another 100, another 200, another 300, another $1 million on the table. Doubling a terrible offer only makes it a bad offer. It doesn't necessarily make it a good one. And I generally tell people that because people will get tricked into negotiating some amount of money over what's offered, and they end up thinking they're getting a great deal, and it turns out they miss some aspect of it that's going to severely destroy the value of the property, and they leave lots of money on the table. So that's why I generally don't recommend just jumping in and talking value without first talking to an attorney. Beyond that, going back to you writing everything down, right-of-way agents are write everything down. They keep contemporaneous notes of all the discussions they have with landowners. So if you tell them I'm entitled to $100,000 during your discussion, they'll write that down. And then let's say no deal is reached, and then you hire our firm, and I say, well, there's another $200,000-$300,000 out here because of some aspect of the acquisition that you might have missed. The problem is that the DOT already knows that you were willing to take 100, and it's going to be very difficult for you to try to negotiate over and above a number that you've already told the DOT that you would accept. It's not that scenario of showing your hand when you don't need to, and you don't need to show your hand in these scenarios, and you don't need to jump into discussions immediately. You have some time, and you have the ability to coherently fight it to get to maximize your result. Beyond that, I don't recommend getting an appraisal unless you absolutely need to. That's a people instinctually when they have their appraisal, TxDOT does, and your instinct is to, okay, well, I'm going to get one too. The reality is that eminent domain appraisals are very expensive, much more expensive than your traditional appraisal for a lender or what have you. They are very expensive. And beyond that, a lot of times they're not necessary. Sometimes they are, sometimes they aren't. My advice to my clients is generally that we don't need to spend your money. I don't need to spend my clients' money unless I absolutely have to. Or I don't want to spend their money unless I absolutely have to. And they don't want to spend their money unless they have to. And it's my view that appraising generally is not necessary unless you're in litigation. A lot of times, we're able to get results for clients without getting an appraisal, without spending that money that to get a number that that you might otherwise be able to get just through attorney representation. So a lot of folks jump into that. I like to preserve my clients' money. I don't like to spend money for these cases, especially because it's not something obviously that the landowner asked for. So I generally don't recommend doing that. Appraising can be necessary, don't get me wrong, but all of my appraising is generally done at eminent domain because at that point it gets into proving your point, proving your evidence, and that requires appraising generally, but not until that point. We already talked about not meeting in person with right-of-way agents. And then these last 2 points, I just want to stress that, and I kind of already talked about it, not to jump into negotiations, not to jump into a decision just immediately upon talking to right-of-way agents. But at the same time, I generally advise folks, again, a lot of people, they get this offer and they don't want to deal with it and they put it aside and they don't touch it. And then all of a sudden they end up in eminent domain because they ignored it. That definitely happens. And I would just advise to, give it the attention it deserves, or just hire an attorney and have them handle it. Speaking of, and I can only speak on behalf of our firm with regards to hiring attorneys. If you're interested in hiring an attorney, a lot of attorneys, well, I guess, again, I can only speak for our firm, but our firm operates on a contingency fee. Contingency fee is contingent on how much we get for the landowner over and above what's been offered by the DOT. In the situation that I've on the slide here, let's say you're offered $10,000 by the DOT, you hire our firm, we get you $100,000. Our firm collects a third of the 90 that we add to the case. If you hire our firm, we don't get you $1 more than what is offered, then we do not collect a fee. So we are incentivized, of course, to do right by you because we are doing right by ourselves. We are all in the same boat together in this relationship. And that's why we do it that way, to ensure folks that we're all on the same side, it's all on the same page, because we are, and we're all incentivized by the same thing. We also do it this way, of course, because landowners don't like to spend money on attorneys. Nobody does. And having to come out of pocket to hire an attorney for a situation that you did not cause or ask for, doesn't seem right, of course. So we are doing it this way to allow folks to hire us who maybe aren't super liquid right now or have the money lying around to pay for attorneys. So this is our general method of representation. If you have, if you're not interested in this type, we also do other types as well. So happy to talk about anything you might be interested in. And with that, I'm coming to the close of my presentation. It is 2:30 or almost, sorry, it is almost 1:30 rather. And so I will take questions. If you do have questions, go ahead and jump in the chat or put them in the chat or the Q&A, and I'd be happy to answer them once I'm done here in a bit. But with that being said, moving forward, when you receive an offer, that's the time to hire an attorney. What I tell people is as soon as you know about the project, that's when you should start looking start maybe vetting attorney options. But once you get the offer, that is the time to hire an attorney, hire counsel when you get the offer. Again, don't rush, but at the same time, there is only one chance at compensation. Once you sign, that's it. It's done. It's over. I've had countless people contact me after the ink is dried saying, I'm not sure if I did this is a good job, and there's nothing I can do at that point. So it's incumbent upon you to be aware of the fact that there's only one chance at compensation. Once you sign it, that is it. If you have questions about eminent domain, our firm, the project, anything really, feel free to reach out to me. Again, my name is Jordan Walker. That's my email address right there at the bottom, jordan@swp-legal.com. You can also call me at 737-252-1936. You can also text me at 470-869-1383. And that includes sending offers. If you just want to send me your offer, I'm happy to look at it and get back in touch with you, probably within the day. So that is the end of my presentation. I will open up to questions if there are any. Okay, I am not getting any questions. You guys were easy. Great. Well, that's fine. If you have a question later, don't hesitate to shoot me a text, shoot me an email. Happy to answer it. But other than that, thanks for stopping by. We appreciate your time. Good luck and contact with questions.